Right now, Heath Brooks with our friends over at Timberlake and League joining us. Always good to have you with us, Heath.
Good to be here.
So while we wait for a call, let's talk about a very important topic. Your liability when you, I suppose, throw a party and you end up serving minors alcohol.
That's right. You know, that's a problem in Alabama. You can actually be criminally liable for that. But not only can you be criminally liable for serving minors alcohol, if you know that it is a minor that you're giving alcohol to and that minor takes off in a vehicle or in a razor, in a golf cart, driving around the neighborhood and causes an injury to somebody, you can actually be responsible if that minor causes an injury, particularly if you are the one who served the alcohol at your party.
So I have a question regarding that.
Sure.
21 is the legal drinking age.
Right.
Kids often go off to college at 18. They don't have the parental supervision. And
Right.
we both know there are plenty of college kids who somehow do gain access to alcohol.
Somehow.
But considering the age disparity there, and 18 in a lot of cases is a legal age, do the laws still hold as firm in that age range between 18 and 21?
You know, it's about a knowledge thing. I mean, whether you're in college and you're going to a party and you're an age majority person serving a minor alcohol, if you are aware that you have given a minor alcohol, that's the important thing. If you don't know, then there's some leeway about whether or not you're going to be responsible if that minor goes out and causes an injury. So it's really a knowledge thing. There's no real distinction about, whether it's in college or whether it's up here in Huntsville or whether it's over in, Florence or any other place for that matter. But it's about knowledge.
And just want to remind folks, we are taking calls right now, 256-536-0077. Heath Brooks standing by to answer those questions. On the same topic, Heath, we are talking about how it is you can be criminally responsible for serving them alcohol. What about the civil side of that? Would that be an easy case to win?
Actually, it's difficult because it used to be in the state of Alabama, and the laws always change. It used to be in the state of Alabama, it was what was called strict liability, meaning if you didn't know that you were giving minor an alcohol and the minor went off and caused an injury, then you're going to be responsible anyway, whether or not you knew they were a minor. Now, it's not so much of a strict liability. You have to have knowledge that you have served that minor with alcohol. And so that changes the ball game, because who's going to admit, yeah, I knew they were underage when I gave them alcohol? You may have to rely upon other witnesses. The important thing, and there's some liability here too, outside of minors. If you're having a social gathering and you're giving alcohol to a bunch of people, and then the people that you're going to be giving alcohol to end up getting out on the road and causing injury, most of the time you're not going to be responsible. But there are some times when you could be responsible. If you give the keys to your vehicle to one of those people that you know is drunk, or have been consuming alcohol, or if you let them take your, around areas, sometimes in neighborhoods, we have golf carts that are riding around. If you give your keys to somebody you know is drunk to your golf cart after a party and they cause an injury or hurt somebody, then you can have some responsibility. There are some other areas. I mean, if you let somebody leave your house that you know is a danger to the community, there is some question about whether you could be responsible, particularly if you provided the alcohol.
And I do believe, Heath, right now we have a caller. Candy, are you there?
Yes.
Go ahead with your question.
If you die and don't have a will, and you have no spouse and no children, does the state take any of your estate, or does your one surviving sibling get it?
Well, so if you die without a will is the question. If you die without a will, then Alabama and most other states have what's called intestate succession, which is a way to establish who takes in the event that somebody passes away without a will. In your scenario, first would be your heirs, which would be your children. And then after that, if you don't have any children, it would default to your parents. And then after that, if your parents have predeceased you, then it goes to your siblings. So the short answer to your question is that if your sister is still alive and that is your only living relative, then most likely all of your assets would be distributed to her. These kinds of situations can get very complicated though, always advisable to have a will, always advisable if you have a question to talk to an estate lawyer who handles that kind of law.
And Candy, we thank you for your call on this Monday. Remember, if you didn't get your questions answered today, you can always call our friends over at Timberlake and League to ask your questions directly, or call us here every Monday during Wait 31 News Midday.